Court of Appeals, Division 1 is now in session.
Thank you. Be seated. Now is the time set for oral argument in cause number 1CACV 160265 and 1CACV 160281, those cases having been consolidated. This is Smartcomm License Services LLC versus John, and I want to say Palmieri. Is that correct? Thank you. Thank you. For your information, these proceedings are being both audio and video recorded. We've told everybody that for the last several years, and the caveat to that is that absent unforeseen circumstances, which over the last 2 years has been possible, but I think we're pretty good at it now. Absent unforeseen problems, you can critique yourself on YouTube. In a few days, you can review opposing counsel and your own arguments today, and that's why it's there.
Critique yourself on YouTube. That just doesn't sound quite right.
You'll certainly be critiqued, so why not? Counsel, each side will be entitled to their customary 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and for the appellant's purposes, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking all your time up. However, ultimately, you need to let us know, and we'll be attempting to watch for that, all right? We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and the issues attendant to the argument. We say that so that you can fashion your arguments accordingly. There are some things you could probably assume, recognizing that we have reviewed the facts and we have reviewed the issues as of this morning. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, the appellant may begin.
Thank you, Your Honor. Dennis Wolinchek and Bartness for Smartcomm. I would like to reserve time as much as possible. I think there are 4 issues that are involved here. Let me start first with the damages issue. The judge never reached the substance of the claims any more than, I would argue, Commissioner Vatz did when he heard all the damages claims in a full day of hearing that these gentlemen were present at. And the odd thing about this case to me is that the Superior Court judge, Judge Anderson, actually acknowledged Commissioner.
Yeah. I need to do something before you.
I'm sorry.
No. It's not your error. It's mine. We just found out when we walked out, and it's kind of out of the customary routine. So I just want to put everybody on the same page here. We were made aware when we left the bench and went into the ready room that last night at about 7 o'clock a motion to take judicial notice was filed in this matter.
Oh, yes.
We have not had time to review it. We may have, if you wish to raise it, you can use your time accordingly. We will ask questions as best we can, really not knowing what the content is, but based upon your argument. But I wanted to let you know it is subject to your argument, and we don't want to deny that to you if you wish to do so.
I'm not going to go into that, Judge, just so you know, because it speaks for itself.
Everybody on the same page? Counsel?
Yeah. So,
right, thank you. And go ahead, Counsel.
Thanks. So basically, just to shorten that up, Commissioner Vatz heard the issue on damages, assuming the same set of facts and predicate that the Superior Court judge should have, which is because he didn't reach the merits of the claims. He dismissed 7 of the 8 of them solely on the issue that there was no fact of damage established, while acknowledging that Commissioner Vatz had a hearing on the murky matter, which, again, we allege they were all co-conspirators, and found as to all of them, if you read that order, that, in fact, the best way to gauge the damages for all of the wrongdoing and misconduct alleged, of all of them, Commissioner Vatz basically, in his minute entry, said that he was wrestling with that issue. The court's task is to find a means for measuring the damages. caused by the murky defendant's wrongful conduct. And basically he goes on and he basically says in his minute entry that the court took notice of, that it is said that Janus would not even exist but for those wrongful acts and those of other defendants as alleged in the complaint. The court agrees that employing this principle, that is the principle set forth in the trade secret statute, is essentially will result in the fairest assessment of plaintiff's damages. And that says it all, and that's why I highlight that at the beginning. Meaning, we never limited our claim for damages to anything relating to the misappropriation of trade secrets. We never said anywhere that I can find in the record that that was our only damage. What we were saying is that that is the fairest, just what Commissioner Vatz said and what the court took notice of and then ignored. That is the best way to gauge what damages are in a case where somebody basically violates your confidentiality and basically goes out and competes with you with it. And what is that? It's really simple. It's not a complicated process. It involves the damage directly caused to us by payments made, in this case refunds that we put out. Commissioner Vatz found the damages to be $13 million compensatory, while the Superior Court judge found we had no damage stated. And then it also involves their profit from the wrongful use of our secret sauce or information.
Counsel, are you asserting that we are bound by the findings or the determinations of the commissioner?
Oh, absolutely not. And
so what is the benefit to us of looking at the commissioner's findings and saying that while a commissioner that we don't really have the entitlement, if you will, even to review his determinations, that we should ignore the judge in this case toward the benefit of the commissioner?
Because the judge ignored the commissioner's findings of substantial damage that were disclosed and put forth to him, which he said, basically, you have no evidence shown of any damage. That is wrong.
Well,
just that alone is evidence of damage.
And in your board, and I appreciate the enlargement being able to read it, the minute entry of the commissioner on 1/20/15 says the court's task is to find a means for measuring the damages. Isn't, in fact, the court's task to interpret the evidence that presents that proves the damages or illustrates the damages?
I'm not following that.
Wait,
The court's
he's
task is
saying
to,
I got to figure out a way to establish damages here, right?
Yeah, pretty much.
He's not saying I have not been given sufficient evidence in order to make a damages determination.
Exactly. That's the whole point. I agree with you.
Okay, all right.
And that's my whole point. There was evidence, substantial evidence for a full day.
Was there evidence presented at the default hearing that was not brought forth in this matter?
No, I don't think so. It was the same evidence. It was the same evidence of the refunds in the 9th and 10th disclosures, and also you'll see it in the motion to reconsider highlighted again. And it was the same evidence of what we had at the time of the lost profits, because again, without going into a long diatribe, we felt that they hadn't produced all of that evidence. But what they had produced is included in his findings. And as I said, the court had those findings. He references them on page 3 of his March 2nd, 2015 order. And then he simply ignores it. And we did argue, in many places, we argued that, in fact, these were the same damages for everyone. We argued that these damages apply to all of the various claims. And you have to understand, Judge, that what we argued here and what the complaint alleged and what we followed up on is a common nucleus of facts, okay? And I'll make it real simple because I don't have the time, and it would take me all day to go into all the details of what we do, how we do it, and so forth. And I don't think it's really relevant because the judge never reached those issues. But you have to understand that the common nucleus of facts, i.e. broadly, that they weren't doing this business. They came to work for us. They signed a confidentiality agreement, which you've seen. They then went out and did something that is identical to what we're doing with our customers and essentially directly competed with what they learned there. And I have tried to liken this to something simple, and the best I can do with it in the time that I have is, you know, their argument is, well, all this stuff was available to the public, okay?
Well, counsel, didn't you make it available to the public? Didn't 3,000 non-customer mail recipients get copies of your trade secrets and your confidentiality issues?
The marketing materials that went out marked confidential to people did provide a lot of the items that are of public record that they're saying.
Okay, and
that isn't our case.
I want to be real clear on this.
Sure.
And I want to get this point clarified is the way I would rather say that. Are you suggesting that by sending 3,000 copies of what you would otherwise refer to as trade secrets and confidential information out in an envelope, much like I get from ARP and any other number of organizations this day that says confidential and privileged on the outside of it, that binds the recipient to something that they have not otherwise agreed to simply by virtue of receiving it in the mail?
No, as I said, our case has been misconstrued.
Well, and I want you to help me with this.
I'm trying.
To the extent that you're sending something out that you assert to be a trade secret and have confidential protections attached to it, but you've sent that out to 3,000 non-contracted parties or whatever you want to call them, just individuals out there, where's the protection of the trade secret?
Okay. It's a question of what the trade secret is, Your Honor. And I think with all due respect, I think you're misconstruing, or they are.
Clarify it for me.
Sure, absolutely. Well, the law clarifies it, and the Act clarifies it, 44401, as well as the contract. A trade secret is not just those items that you refer to individually at all. The trade secret, anybody receiving that brochure would have no way of doing what we do. Let me make that even simpler. Okay? Just having those items or any items. Let me liken it quickly to, as I started to say, the Colonel Sanders secret sauce, okay? Because I think it's a simple example that works. So every one of the things that goes into the Colonel's recipe is certainly available to the public and provided to millions of people. Salt, pepper, molasses, whatever.
But how he mixes them.
Exactly. And that was done by no one in the marketplace. No one understood how to mix it except my client, who was really the only one that ever did it, until these guys went out, learned, in violation of our agreement, and the Trade Secret Act makes it absolutely clear, more clear than I could, that it is that compilation, if you will, that coordination, that methodology of putting together those items. No one who received those 3,000 brochures ever went into business competing with us because they couldn't with those brochures or that information. That doesn't give you the formula, if you will, as to how to go out and do this. And that's as simple as I can say it. And the Trade Secret Act is clear on that point, and also all the cases that I could go into that deal with it, that make it clear, look, it's not a question that they try to argue to the court that these individual items individually by themselves are available to people or in the marketplace. That's true, like I said, of every ingredient in the Colonel's recipe.
Why did they stamp the envelope confidential if this wasn't something that you believed was confidential?
Well, I'm not arguing that it wasn't intended to be confidential. What I'm arguing is answering, I think, your question, does that end the controversy? And I'm saying it doesn't. The fact is that what our case really is has nothing to do with those individual items or those brochures. They tried to make that our case and mislead the court, in my opinion, into thinking that's our entire case, which apparently you're thinking too. That's not our case. So our case is not...
Did Judge Anderson rule that because you sent out these 3,000 packages to various members of the public, that those were the trade secrets and therefore you had no trade secrets?
You know, Judge, I'd love to answer that question honestly to you, but I can't.
Why not?
Because Judge Anderson didn't rule anything except to simply, a day before the trial, on a Friday before the Monday trial, jury trial, to simply dismiss our entire case with no reasoning at all and say it'll follow, didn't clarify in any reconsideration, didn't say any reason. So I'd love to answer you, but I have no clue in all candor, and that's one of my problems, as to what he thought or did or why he did it. All I know is that we stayed...
It would only be part of his ruling, if indeed it was. It would only be part of it, as I understand it.
No, let me make it clear real quickly. He dismissed 7 of the 8 claims on damages, and then right before the trial, and again, that was before discovery was completed, and then right before the trial, literally right before the trial, he just issued a minute entry on that Friday telling us not to come to trial because he's dismissed the remaining count, which he did find damages for, and it was the same damages that we're talking about. And again, I can't make heads or tails of that, to be very candid and blunt. He found that there were damages for misappropriation, but our argument is it's the same damages. We're talking about a common nucleus of facts arising out of the same issues on all legal counts that were brought surrounding those facts. It's the same damages. We never conceded anywhere that the damages were different at all. And so I can't answer your question as to why he dismissed it on the trade secret. I'd love to, and I'd love to parse it out. I can't because I have no clue. He just did it to get rid of the trial, in my opinion, for whatever his reasons are. And all I can tell you is that the compilation, the methodology, the coordination of all of that information was unique in the industry, is unique in the industry. No one has ever figured it out. They didn't figure it out until they came to work for us and signed our agreement, and then took it and unfairly competed and breached fiduciary duties. And all of them conspired and aided and abetted, and they're all individually liable for doing so. I cannot understand how a judge can dismiss a case saying there's no damage from that conduct, assuming that conduct to exist. Particularly, I say, in light of the findings of Commissioner Vats. And are they binding on any of those people? Not directly, but certainly it's evidence to the court when dismissing your entire claim on a basis that you haven't shown a fact of damage, that a Superior Court Commissioner heard a full day of damage, the same damage, and found that there was significant damage and a methodology to compute it. And we disclosed all of that.
Notwithstanding my years in private practice, I don't recall ever seeing a situation where a plaintiff is opposing a summary judgment motion, which is based in part on lack of damage, and that you can successfully oppose it with a default judgment against other parties.
That wasn't only it.
How do you do that? How do you get that in front of the court and the current parties?
Well, we did, and he accepted it. It's not a question.
So are you saying that based on what happened in the Palmieri matter, that everyone else is bound by that decision based on the case?
Murky was alleged to be their co-conspirator in this case.
Not my question. Are you saying that something that the other parties were not even a party to? Palmieri was a default, right?
Murky was a default for discovery abuses, and they were parties to the case with Murky as aiders and abettors and co-conspirators.
Are you saying that in the record we will find a record where all of the other parties came in and defended Murky's case, which otherwise might be, the judgment might be alleged against them?
Well, I'm not alleging the judgment of Commissioner Vats is directly. I said that.
You're not saying it's res judicata or
no, I've not said that. I'm saying it's evidence
of damages.
That there was a damage for a court to not dismiss a case, but more importantly, it's the same damages that were disclosed under Rule 26.1's clear requirements, that the only thing that you're required to disclose is the damage and the calculation of damage. There's nothing in there where it makes it certainly clear, or even says, or even alludes to the fact that you have to make a magical statement that, you know, this applies to all of our counts. I mean, I think it's pretty obvious, unless you say otherwise. And we didn't. And so all I'm saying is, at that point when we supplemented, because we did oppose properly providing the 9th and 10th disclosures after we took additional discovery, and provided what our damages were. So I don't want to mislead or have the court think that we didn't do that. We did do that.
So where in the record do we find, in the summary judgment record, I'll call it, do we find the evidence that was presented at the default?
Yeah. It was our disclosure statements that were provided as part of our response to summary judgment. Exactly, which provided the calculation of damages, a chart which details out those damages as best as we could at the time, that shows the amount of refunds attributable to them and shows the calculation of the amount of lost profit that we assert was caused by their doing business in violation of their confidentiality and in violation of the statute. It's not rocket science. I mean, that's all you're required to do under Rule 26.1. And frankly, the court concluded, and I truly don't understand the conclusion, after indicating that information that I just went through with Commissioner Vats, and indicated that we did not state our damages, that they were speculative somehow or something. That's a jury question. I mean, that's the biggest issue I want to leave you with. These are not for the court to decide when you set out your damages and make a legal determination, nor is it a legal determination to determine whether it's a trade secret for that matter. The cases are replete saying it can be sometimes a mixed question of law and fact.
But the court always has a gatekeeper role to see if there's a triable issue of fact.
Absolutely, I agree. But we certainly met the gatekeeping function, if you want, by indicating in detail in the record that what our I mean, we have a lengthy complaint. We have lengthy disclosures. We responded to the summary judgment motion, and we set out in full what our secret sauce was. Now, he may not have liked that, but it was factual in nature, and it was a methodology that he couldn't have ruled as a matter of law. We couldn't go to a jury on. I'd like to reserve, if you don't mind. I'm sorry. Thank you.
Thank you, counsel. Are you going to be the only counsel speaking today on behalf of?
Fortunately or unfortunately, no, I will not be, Your Honor.
And you've agreed as to the time division?
We have agreed.
Thank you.
Your Honor, my name is Lance Broberg. I'm from Tiffany & Bosco, and I represent Dave and Elizabeth Alcorn, as well as Dave Alcorn Professional Corporation, which we frequently refer to as DAPC.
Are your particular clients bound by the Palmieri decision of the
No.
commissioner?
No,
Why?
Your Honor.
Why?
We were not parties to that particular result. There's two components to it. First, there was the substantive finding of default. That was, as Mr. Wilenchek explained, that was the result of a discovery sanction. It was not a substantive finding of liability. With respect to the default hearing, slightly different than what Mr. Wilenchek said. I attended. My co-counsel here today did not. I simply went as a member of the public because at that point I was still trying to figure out whether this was a $10,000 case or a $10 million case. We were not parties to that particular hearing. We didn't have an opportunity. No. I knew that would happen. We did not have an opportunity to present a defense, and I'll tell you that no real defense was presented. Mr. Murky did not attend that particular hearing. There's an interesting discussion about how he was present and spoke with counsel, but then was hiding outside of the courthouse as opposed to coming into the courthouse. At the end, and this addresses one of the questions that you asked a moment ago, we're not bound to what Commissioner Vatz said. And I think it's important what you noted that what Commissioner Vatz said. Commissioner Vatz was trying to figure out how the heck am I supposed to determine what the damages are on this. And ultimately what he said is, I'm going to focus on the remedies that are available for a trade misappropriation claim. The trade misappropriation claim is absolutely irrelevant for today's proceedings because we were not granted summary judgment on the damages motion for summary judgment relative to the trade misappropriation claim. Trade misappropriation is entitled to a remedy that is entirely different than, for example, a breach of contract. Trade misappropriation under the statutes permits a party to seek an option of remedies. That includes compensatory damages. That includes the ability to get what I frequently refer to as the ill-gotten gains or the profits that were obtained by the alleged wrongdoer, as well as potentially almost a commission. I'm failing in coming up with the word, but the equivalent is a percentage of proceeds that are derived off of the sale or use of those proceeds on a going forward basis. Those types of remedies are not available for the other 7 causes of action.
And that's why you didn't get summary judgment on the one?
I think there's a couple of reasons why we didn't get summary judgment on the trade secret claim. Now, I'll walk through those. One, this was not a short process, as your honors are well aware. This matter was briefed over the course of 15, 16 months, multiple supplemental responses, multiple supplemental replies. The only actual hearing that took place was on a Rule 56F request. And at that particular hearing, as noted in the minute entry, the March 2nd, 2015 minute entry, what plaintiffs identified are their damages were every cent that Janus ever made, and then the refund obligation damages. When we came and ultimately presented it, we said, well, that's interesting, because if you say that, then certainly you have evidence of the refund damages. You have to have a contract with your clients that shows you're obligated to give a refund. You've got canceled checks, you've got account statements, you've got declarations or affidavits or something showing what refunds you've actually given to your clients. Smartcomm never produced those. They refused to produce those. In fact, the only document we got, which is referenced in that March 2nd minute entry, is a letter from Smartcomm's general counsel that says we're not giving refunds. So from our perspective, that was the only damage available for example, the breach of contract or the tortious interference. We were alleged to be tortiously interfering with the contract between them and their customers. And so if they wouldn't provide those contracts or any evidence of damages, how are we supposed to defend on that? With respect to the trade misappropriation, the discussion was this. For years, we were embroiled in contentious discovery battles. And those discovery battles focused on allegations that we had information and we weren't disclosing it, we weren't providing it, we weren't giving it to them. And we got to the point where we became extremely frustrated because how do you prove a negative? And what we decided is, you know what we're going to do? We're going to have all of our assets. So our smartphones, tablets, computers, we're going to have them forensically analyzed and mirrored by a professional. And we're going to create a repository and we're going to give Smartcomm access to all of them and say, have at it, guys. If there's something in there, tell us what it is. And we did that, and that's the repository that's referenced in the briefing. So that process took place over the course of the same briefing that we were dealing with the damages. Now, in the court's minute entry, when the court sits there and says, well, and I forget the exact language that the court used, but it said something, it said that defendants, me effectively, obliquely conceded that genuine issues of material fact preclude summary judgment. I don't think I obliquely conceded that. I think I focused on the other ones and said that trade secret is a different animal. And then the court went on to say, but it's not the court's job to do the facts. I should have explained that a little bit better. So fine, that's on me. And then what the court ultimately did is the court said, but we have Commissioner Vatz's decision over here. And Commissioner Vatz said, well, there was something to that trade misappropriation. And so I think what Judge Anderson ultimately did is just said, there's at least something there where there's nothing relative to the other claims, and I'm going to let those go. And I'm going to let that move forward. And so ultimately, the trade secret issue has nothing to do with the damages motion for summary judgment because it survived the motion for summary judgment and was resolved later for separate reasons, that being the failure to produce the customer and IMR lists, and that because they had, as Judge Jones has indicated, because they mass mailed the marketing materials. And that's a subject I'll get into momentarily.
What about Smartcomm's argument that the damages are all the same? These are co-conspirators. The damages are alleged against all of them.
Two problems with that. First, the whole co-conspirator concept. Look at the briefing at the trial court level. At the trial court level, Smartcomm doesn't reference that in its briefing. It only talks about the trade misappropriation claim, and it makes a passing reference to the breach of fiduciary duty claim. It doesn't say there's separate liability that attaches because of the co-conspirator, because of the conspiracy claim, because of the aiding and abetting. It doesn't say any of that. Secondly, the trade misappropriation claim is a statutory claim. And so, for example, an aiding and abetting or any of those other claims is generally not going to get them into the damage analysis or discussion there. Again, the trade misappropriation claim is different. It is simply a different claim that allows for different remedies. And going back to Commissioner Vatz. Commissioner Vatz is as you indicated, Commissioner Vatz is doing the best with what he has.
Let me ask you a question, and do not lose your spot, but now we're back to Commissioner Vatz. I want to read something to you.
Sure.
Commissioner Vatz is quoted as saying, the court must take all of the allegations at the Mayerke hearing, all of the allegations as established for purposes of determining damages against the defaulted Mayerke defendants. So as I understand what Commissioner Vatz is saying is, I have to accept the allegations. So it's kind of like twice removed for the other parties if you're saying, if Smartcomm wanted to say, we established damages at the commissioner's level, and those should have been just accepted because of the presentation of evidence, that's one thing. But for the commissioner to have said, and I will say it again, the court must take all of the allegations as established for purposes of determining damages against Mayerke, isn't that kind of like twice removing any opportunity for the other parties to actually defend the issue of damages?
I would agree. And I would agree, and I would add that there's case authority, and unfortunately, I just reviewed it yesterday on an unrelated matter, but there's case authority that talks about with respect to damages, the court cannot rely exclusively on the allegations in the complaint. The court needs to go farther with respect to damages.
The whole purpose of having a
Correct.
damages hearing.
And at this damages hearing,
So let me ask this based on what Judge Thompson just said. So effectively, we could easier find that the commissioner was wrong as to the standard to be applied to the circumstances he found himself in regarding damages than to find that the other parties are bound by those decisions. Is that a fair statement?
If I was Kent Murky's counsel, I'd be here making those arguments, 8 days a week, Your Honor. The reality is yes. That's the answer to your question. There are a number of faults from our perspective with respect to what happened at that particular hearing. I haven't focused on those because obviously I don't have a dog in that fight. But as they relate here, one of the things that Mr. Willenchek said is, listen, we incorporated all of that and we produced all those documents and we produced the same evidence as was presented in that default hearing in this particular case. I'll do what I did frequently throughout this case, which is I'll do my best Rod Tidwell impression from Jerry Maguire. Show me. Show me where it is. And that's what we literally spent years doing in this particular case. It's one thing for them to say we provided a disclosure statement that has conjecture and a conclusory statement that says we have $10 million in damages, a nice round number.
Well, I think I thought the assertion was that all that is required is to show the amount of damages claimed and how they're calculated. That's what I heard.
No, there's two things. They had to prove the fact of damages, that damages actually existed, and then they had to provide some evidence of the computation of damages.
But I mean, I'm seeing a disagreement between appellant and you as to what's required on summary judgment.
Right.
Have I got that right?
I assume so because we're here. The reality is our position on what's required for summary judgment is they have to demonstrate both the fact of damages and they have to demonstrate and evidence some form or mechanism of computation of the damages. Here,
Are you saying they only did the second and not the first?
I don't even think they did the second. When you look at it, they provided no evidence of it. They provided some kind of a computation, and ultimately they simply said we're entitled to more than $10 million. So they made an ask. And I can ask for a lot of things, but it doesn't mean I can evidence any of those things. And in this particular case, for example, the refund damages are a good kind of exhibit of that. Because if you look at those refund damages, they couldn't provide the contracts. They couldn't provide any refunds that they had given. They couldn't provide any of that information, which means they couldn't give us any ability to compute what the damages were. Did they have to give 1 refund, 10 refund, 100 refunds? They couldn't give us any ability to determine whether or not they actually had given those refunds or might be obligated to give those in the future. So it's one thing for them to come in and say it's 10 million or more, but they can't explain how they got there.
What did the numbers eventually come down to? Their assertion of multiplied millions of dollars in refund damages. What did the number actually come down to?
In the default hearing?
Ultimately, what was determined to be the refund number that was really in play?
I have no idea. I don't know as of today.
If I said $170,000, would that?
There are separate cases and claims that went around, and there were numbers that were thrown about 170,000. There's candidly there was a bankruptcy involved. There's other matters. I don't know what their damages were.
Was there ever a better case made that it was tens of millions versus 172, or 172 versus tens of millions?
My first hearing in this case, I said I don't know if it's 10,000 or 10 million. The last hearing, I was willing to make the same statement because I simply didn't know. They had not disclosed any obligation to make those refunds. They had not evidenced making the refunds or whether or not they were going to make those refunds. They simply didn't do it. And remember, the refunds were only relevant to the non-trade or were the only potential damages identified for the non-trade misappropriation claims. And they simply didn't provide any evidence of that. And now
Was there an adjudication or a determination by the Superior Court of the adequacy of the 9th and 10th disclosures and of whether they complied with the disclosure rules?
To my knowledge, the court never addressed that. The court just didn't go into any more detail than what you see in that March 2nd minute entry, and then there was some more in the Rule 59 motion that followed.
Was there a motion to strike the 9th and 10th disclosures by someone on your side?
From our perspective, the 9th and you're testing my knowledge, and I can't say yes or no. That's obviously something we can go look at and get you an answer, but I just don't know it off the top of my head. And also,
I didn't know. That's why I was asking.
We're on equal footing on that. And with
Not to put words in Judge Gimmel's mouth, but I suspect he's exploring the potential different standard for what has to be disclosed in the disclosure statements as opposed to what the required responsive proof to defeat summary judgment is.
Correct. And I would give the analogy, there's a case that's cited in there, the JDM case. It's the John something Mitchell case. And all of the parties have cited it. And it pulls this language that says you have to identify with specificity, and it's focused on trade secrets and trade misappropriation. It talks about what you have to be able to produce in order to be able to satisfy the standard.
For the disclosure or for summary judgment, to oppose summary judgment?
For summary judgment and relative to a trade secret case. And the key part that I'm thinking of right now in my mind is there was a big dialogue between the court and counsel, which is the same that happened here, which is the court was asking for give me the dimensions and specifics relative to your cool IMAX camera and projector. And the other side kept saying it's in the disclosure statements, it's over there somewhere, and the court said that's not sufficient. You have to give me the exhibit and show me the exhibit. And in that case it was Exhibit U. And the court said, but Exhibit U refers me to something else, which refers me to something else. That's not sufficient. Your obligation is to go, here's what it is. It's 6.22, and this is how we get there. And that's the exact same kind of discussion that we had throughout this case, which is what are the damages? Smartcomm wouldn't say it. They'd refer us to a repository or something else, but they wouldn't specifically say it. And I want to make sure that my counsel get an opportunity to speak, so I apologize if I have to interrupt.
Scott Rogers of Osborne Maladon. I represent John Palmieri and his spouse in this case. Your Honors, I will try to be brief unless you have questions for me. My main purpose is to make sure that you do not lump Mr. Palmieri in with the other defendants. He is different. He's not an owner of Janus. He didn't run Janus. He didn't sell any applications.
So, excuse me, counsel, but are you telling me that the entirety of the Mayorki, the commissioner's judgment in Mayorki can't be applied against Mr. Palmieri?
Yes.
What possible basis could you have for that?
Your Honor, the theories against that have been expressed simply don't apply. For example, let's focus on the damages. The damages theory that they're espousing comes down to refund obligations that are based on a premise that Janus applied for applications that then deprived Smartcomm customers of applications. Mr. Palmieri didn't apply for any applications. There's no evidence in the record of that, and in fact, he didn't do it. The other theory for disgorgement of Janus's profits is not Palmieri's profits. So he is different in many respects. There are several arguments that are urged as error in Smartcomm's brief that by their terms don't apply to Mr. Palmieri. For example, issue number 3 about Mr. Alcorn's contract has nothing to do with Mr. Palmieri.
So you think there's a way we could affirm as to Mr. Palmieri and reverse as to the other defendants?
I think that's possible, Your Honor. I think you should affirm as to all, because I think that Smartcomm failed its burden.
Glad you here. Right?
But the point, Your Honor, is, and we heard it again in Mr. Wilenczek's argument, Mr. Palmieri gets lumped in with them, even as to theories and as to facts that cannot apply to him. Let me give you some more examples. Under a trade secret misappropriation claim, they have to prove that Mr. Palmieri disclosed, misappropriated. It's not enough that some other defendant may have done it. They have to prove it as to him, and they haven't done that. He was both a customer and a marketing representative. He got information from Smartcomm that he was entitled to receive. And under his agreement, Smartcomm told him that they would tell him in writing by marking documents confidential and proprietary if they were deemed confidential under the agreement.
In fact, wasn't that kind of an exclusive statement? The agreement, did it not say that all such documents would be so marked?
You're correct, Your Honor. The language says licensed services, which is Smartcomm, clearly will mark any such confidential information as confidential and proprietary.
How much did you get that was marked confidential and proprietary?
Not a single document in the record, Your Honor. Not a single one. The brochure, the marketing brochure sent to 3,000 people said confidential, but not a single document in this record says confidential and proprietary. That's a burden that Smartcomm imposed on itself, and by not following its own contractual obligation, it didn't exercise reasonable efforts to maintain the secrecy of the information. That's all I have, Your Honors, unless you have questions for me.
I have 2 minutes. It's a 2-minute warning. Thomas Littler representing Janus Spectrum. I'm sure, as you know from the record, Janus Spectrum was the company that was established that actually engaged in the same kind of license and business as Smartcomm was, with some differences. It wasn't exactly the same. Regarding the VATS hearing, I want to make clear I was not at that hearing. I had no opportunity to defend that Janus in that case. I had no opportunity to ask questions. I wasn't even there.
But merely being there would not necessarily change the legal landscape anyway, would it?
Well, it wouldn't. I just want to make it clear because it was said that we were all there, and he was there, but I wasn't.
Was it ever suggested that any judgment obtained at that hearing, at the VATS Commissioner VATS hearing, might be later? They might later attempt to impose that judgment against you?
No, not at all. And we obviously had serious issues with the evidence there. We would have objected to certain evidence. We would have objected to disclosure. We would have all kinds of issues that we would have argued relating to the allegations as well as the damages that were asserted.
Counsel, how do you interpret the provision I read from the Commissioner that says the court must take all of the allegations as established? Just the way I read that is by virtue of being an allegation, the Commissioner must accept it as being established evidence.
Correct, which is also related to causation. I mean, he has to accept allegations regarding the wrongdoing, the alleged wrongdoing is true. He has to then accept causation, which was a big issue in this case. We're alleging none of the damages they were asserting were caused by the behavior because there was no misappropriation. So he's got to accept that all these numbers that they threw at him at the hearing were caused by the 8 or 9 counts. So and he had to accept that. He didn't have that right, and we had no opportunity to go in there and say, no, you can't, because it was a default hearing. I have 10 seconds. I did not get notice of the judicial notice on the SEC judgment. I handled that case. If you have any questions about it, it's not a final judgment.
Let me ask you one question real quick. Does anything about the judgment that we have not yet, does anything about the filing we received, the motion to take judicial notice, does anything about anything that was decided therein alter the issue of Smartcomm's ability to allege damages here?
No.
Okay.
Thank you.
Quickly on that last point, Your Honor, the only point that I would add to that would be that it shows that another court also found the same damages that we've been asserting, okay?
Counsel, can I just clarify one thing from the colloquy we just had? You're not seeking to impose the VAT's conclusions in this case. You're wanting to use that as evidence of your damages.
Yeah, just to show. That's right. That's exactly right.
Or anything like that?
You got it. That's exactly it. I don't know what the confusion is. We didn't argue it was binding on these guys. What we said to the court was, if you're going to say that we haven't established a fact of damage, and you do, and you're on page 3 of your minute entry on your ruling, admit the fact of damages as to the trade secret claim, using that opinion, that was a court doing that, not me, then obviously we've given sufficient notice that there is a fact of damage and that we've, in fact, been substantially damaged. We weren't trying to say that establishes conclusively the damages to them. We were saying on a summary judgment motion, when you're throwing out a claim, 7 of the 8 claims, on the fact that there's no damage at all, and you find that that ruling does support the fact that there are damages for the trade secret claim, then the only issue, going back to Judge Gemmel's point earlier, was then why is that materially different than the damages for the other claims that we need to establish? And it isn't. And that's just a false statement. The damages are the same out of the same nucleus of facts because that nucleus of facts doesn't change. Yeah, we all know as lawyers we have different counts that deal with that. But the damages arise out of the wrongful competition, however you want to legally assert it.
What if somebody said, well, you know, on summary judgment, your duty is to come forth and demonstrate that you have triable issues of fact and that you have admissible evidence to go before the jury.
Sure.
But Judge or Commissioner Vatz's default is not going to be admitted before the jury.
I repeat, Your Honor, 2 things. First, we did provide that evidence, and that's been lost in the shuffle here. Okay. We did provide evidence of refunds and checks, contrary to what was stated here. We did provide a detailed list of our refund damages, as well as our the lost profits that we claim.
That's in the 9th and 10th disclosure.
Yes, that was in as part of our response to the summary judgment, and they're verified and so forth. So it's false to state somehow what he's really stating, and again quickly, is that you didn't provide enough evidence of the background to all of that. That's not required to defeat a summary judgment motion to get to a jury on the case. All you have to show is that there's a material issue of fact on the issues, and that was true on the trade secret claim. There were clearly material issues of fact and dispute, and it was true on damages. They can dispute the damages, but they can't argue that we haven't told them what the damages are. That's the whole point of this case. And then, of course, there are other parts we haven't even touched on today in the interest of time. You know, the injunction issue, which I think is important. And quickly, I don't know what that has to do with any of the stuff I've just argued. There was a separate stipulated judgment that they violated, and the court dismissed it as moot for reasons beyond me to understand. I'm sorry to go so fast, but you can see the time.
I've been accused of speaking quickly myself once or twice.
Unfortunately, time just goes by.
It does.
Yeah.
It does.
Okay, well, unless you have any questions, Your Honor, I'm done.
I think we're good. Thank you.
Thank you.
Counsel, all of you, we appreciate your participation today. We appreciate your willingness to listen to our questions and attempt to answer them as best you could. Thank you. It's been helpful. We will take the matter under advisement. We will rule in due course. Thank you.
Thank you.